Good morning and afternoon, everyone. Thank you for joining us for the final webinar in Fasken's four-part EDI series, Accommodation and Bona Fide Occupational Requirements, Meeting the Thresholds. My name is Andrew Dixon, and I'm a partner in the Labor, Employment, and Human Rights Group here in Fasken's Calgary office. I act for employers across a range of both provincial and federally regulated workplaces, and my practice covers all areas of workplace law, including, of course, human rights matters, accommodation, and resulting litigation before the provincial human rights commissions and tribunals in BC, Alberta, and Saskatchewan. Before we continue, I'd like to provide a land acknowledgement. First Nations and the Inuit have been present in Canada for thousands of years. These Indigenous peoples have a profound and ongoing attachment to this territory. At Fasken, we recognize that we have a role to play in the ongoing process of reconciliation between Indigenous and non-Indigenous communities here and elsewhere in Canada. We have embarked on a reconciliation journey by adopting a plan with the overall purpose of contributing meaningfully to reconciliation. While I introduce you to our other speaker today, please see an information slide that's on your screen. I'd like to draw your attention to the survey piece. We value your feedback on our sessions and encourage you to fill in the survey before you log out of the webinar today. We also have an automated process for those who require Ontario and Quebec CPD certificates. At the end of this webinar, a QR code will appear on your screen and a link will be added to the audience chat that will allow you to receive a certificate once you provide your information. For those who aren't able to complete this process today, certificates will be sent next week. So next, it's my pleasure to introduce my co-presenter for today. My co-presenter is Rachel Younan, who's a partner in the Labor and Employment and Human Rights Group at Fasken's Toronto office. Rachel provides advice and representation to both unionized and non-unionized employers across all areas of labor, employment, and human rights, including providing advice on accommodation and acting for employers in human rights complaints and grievances related to accommodation. So now on to our presentation. Here's our agenda for today. We're going to start by giving a little bit of background, just to level set and make sure everyone's at the same place when we talk about what it means to have discrimination and accommodation and undue hardship. And then we're going to go and talk through some various examples. So as I'm sure most people are aware, there's an obligation to ensure that most workplaces have a workplace that's free from discrimination. And this comes from a number of sources. The primary source is human rights legislation, and human rights legislation exists at both the provincial and the federal level. The provincial human rights codes include the provincial human rights legislation include the Human Rights Code of Ontario, the Alberta Human Rights Code Act, and the BC Human Rights Code. In each of these, they set out the requirements that employers have to ensure that they're not discriminating on any protected grounds in the workplace. And we also have the federal legislation. Generally, with few exceptions, the provincial codes or acts are going to apply to most employers. Employers who are federally regulated, generally you know who you are, and it'll include interprovincial transportation, telecommunications, and other federally regulated industries. And when we talk about discrimination, what we're talking about is discrimination on a protected ground. So each of the provincial or federal pieces of legislation set out enumerated grounds upon which employers cannot discriminate against employees. Each province is slightly different. We have up here the slide from the Ontario Human Rights Code, which sets out the various protected grounds, including race, ancestry, place of origin, color, marital status, sex. And for the most part, these grounds are fairly consistent across the provinces, but there are some differences. And when we talk about discrimination, we're talking about a few different types of discrimination. There's direct discrimination, indirect discrimination, and systemic. Direct discrimination is the type of discrimination that you most commonly think of when you think of what discrimination is. It's essentially an act or a standard that has an adverse impact on someone with a protected ground. So for example, an example of direct discrimination would be something like a policy that says no women can be hired as a firefighter. That's directly discriminatory against women on the basis of sex and gender, and it creates a general policy that women can't be employed as a firefighter. Conversely, we have indirect discrimination, which is when there is a standard that may seem neutral on its face and affects all individuals, but it affects certain individuals with a protected ground more than others, or it treats them differently. So, for example, sticking with the firefighter example, a policy that states that all firefighters must be at least 6 feet tall could be an example of indirect discrimination. And that's because it has an indirect effect of excluding most women from meeting that standard. And lastly, we have systemic discrimination, which is similar to both. It could be both direct or indirect, but it arises out of practices or patterns of behavior that have perpetuated negative impact on hiring or employment or advancement of a particular group. And it's based on stereotypes, and it affects a large majority of that protected group. And so where an individual has a protected characteristic, there is a duty to accommodate placed on employers. And that accommodation is a two-step process. One, an employee has the onus to establish on a prima facie case a discrimination on a prohibited ground. And if they're able to show that they have a protected ground and that they've suffered from an adverse impact, then the step two moves to the employer, who has to show that they've provided accommodation up to the point of undue hardship, or that they have a bona fide occupational requirement. And so let's look at that a little bit closer. So in order to establish a prima facie discrimination, an employee has to have a characteristic protected by legislation. This can be easy or difficult to prove depending on the circumstances, but there has to be something, a characteristic in the applicable legislation that they're protected. The next is that there has to be an adverse impact. So, for example, an employee has to be terminated, or they have to experience an adverse impact based on a policy. And then it has to show that the protected characteristic was a factor in the adverse impact. So just picking a simple example, someone is pregnant and they're terminated, and they show that the termination was that the fact that they were pregnant was a factor in their termination. That establishes prima facie discrimination. After prima facie discrimination is established, the onus then shifts to the employer to show that they've met their duty to accommodate. And under the duty to accommodate, an employer has an obligation to provide reasonable accommodation up to the point of undue hardship. And there's two components to this. There's both a procedural component and a substantive component. The procedural component is the component that gets a lot of employers in trouble. Ultimately, what it means is that there has to be a process for accommodation, and employers have to undertake this process, even if ultimately accommodation is not possible. The procedural duty involves considerations, assessments, and steps taken to respond to the accommodation itself. It's what did the employer do to consider the accommodation? How was it considered? And importantly, how was it documented? So that if there ever is a complaint, how can an employer show a commission or a tribunal that it fulfilled its procedural component of the accommodation analysis? The next process is the substantive component, and that's all about the appropriateness or the reasonableness of the accommodation itself, including proof of undue hardship, which we'll discuss later, if no accommodation is possible. And so in each case, in determining what's reasonable, it's clear the statement that's made by commissions across the country is that accommodation is a two-way street. There's an obligation on both the employer and the employee to participate in the accommodation process to provide a solution. But it's also important to realize that when an employee is seeking accommodation, they can't expect a perfect solution. An employer only has to provide reasonable accommodation. And so that can be a wide range of options. And an employer can meet its obligation to provide reasonable accommodation, even if it's not the employee's preferred accommodation. So one of the defenses to providing accommodation is bona fide occupational requirement. And a bona fide occupational requirement is a standard or a policy that's reasonably necessary to ensure the efficient, economical, or safe management of the workplace. And it's used as a defense to prima facie discrimination, essentially where an employee alleges discrimination. If an employer has a bona fide occupational requirement which resulted in that discrimination, then they're going to then a tribunal or commission will find that they have met their obligations and that there's no discrimination. But the test for a bona fide occupational requirement is fairly difficult to meet. First, an employer has to show that this established standard or policy has a rational connection to what the employer is trying to achieve. The second is that it's been implemented in good faith, and finally, that it's reasonably necessary. And to show that it's reasonably necessary, an employer must demonstrate that it's impossible to accommodate individual employees who have that certain protected characteristic without those accommodations proving to be undue hardship. So looking at the first one, rational connection. The purpose of the standard in question has to be rationally connected to the performance of the job. And so there's two inquiries here. There's the general purpose for the standard, whether it's going to be safety, efficiency, and the second is whether or not that standard is rationally connected to achieving that purpose. So, for example, there could be a general purpose of wanting to ensure a safe and healthy working environment. And the standard then is something like drug and alcohol testing. And so then the question that has to be shown is drug and alcohol testing rationally connected to improving a safe and healthy work environment? And for safety sensitive positions, we know that it is. Now, the scope of what might be permitted in drug and alcohol testing is always a question and will depending on the circumstances, but it's been recognized that a general purpose such as health and safety is a reasonable purpose for employers to implement a standard, and implementing drug and alcohol testing can be rationally connected to that performance depending on the circumstances and the employees in questions who will be subject to it. The next step is that it has to be implemented in good faith. So there can't be an other purpose or nefarious purpose for why the standard was implemented. And in general, the commissions and tribunals have held that this is a fairly easy bar to meet. Ultimately, if it's not challenged or absent any suggestion or evidence that it's implemented for a dishonest or bad faith reason, the tribunals and commissions will assume or presume that this branch of the test is met. But that leads us to the most difficult question, which is whether or not the standard was reasonably necessary. And the main question there is whether or not an employer can, whether the employer cannot accommodate individuals or employees without experiencing undue hardship. And the employer always bears the onus of proving that some standard is required in order to meet the standard that it's connected to, and to ensure and to prove that undue hardship would occur. And so there are a number of questions that have been formulated through the case law that speak to, or at least are considerations for when a standard might be reasonably necessary. And the questions that the courts and tribunals will ask is, has the employer investigated alternative approaches? So if there are alternatives which are less invasive, then a standard's not going to be reasonably necessary. And so going back to our question of drug and alcohol testing, the tribunals and courts have held that drug and alcohol testing is not reasonably necessary to improve safety and efficiency where an employee is not in a safety-sensitive work environment. There are other measures that could be implemented, and imposing drug and alcohol testing on non-safety sensitive employees, it doesn't materially improve health and safety. Similarly, if the alternative standards were investigated, why or why not did they not meet the employer's purpose? So what were their shortcomings? How was this standard that was implemented the only one that would work, or at least one that would work out of a number of options? And is it necessary to have all the employees meet this single standard, or could there be reflective differences in the policies to account for individual differences? So essentially, can you accommodate individuals in their particular roles based on their protected characteristic? Is there a less discriminatory measure that could have been implemented and still achieve the purpose? And is the standard properly designed to ensure that the desired qualifications or standards met without placing an undue influence on other employees? So overall, courts and tribunals will really look at, was it reasonably necessary in the sense that, was there any alternative? Was there any less invasive measures? And if a different alternative was provided, would there be any adverse impacts on other employees or place an unfair burden on them? So examples of bona fide occupational requirements. In some cases, age requirements have been found to be bona fide occupational requirements, and this is certain mandatory retirement ages for certain positions, such as airline pilots, where it's been upheld that age directly impacts an ability to perform an individual's job. Now, for each of these, it completely depends on the workplace and the circumstances. Every bona fide occupational requirement is going to be looked at on a case-by-case basis, so none of these can be assumed to apply generally. It's always going to depend on the specific workplace. The most common bona fide occupational requirement is safety standards. So, for example, safety standards that require employees to wear hard hats, safety standards that require employees to wear respirators, or safety standards that require individuals to refrain from drug and alcohol use. And lastly, physical fitness standards is another one that's been recognized, where in certain circumstances, such as police forces, it's been found that there is a certain level of physical fitness that's required in order to properly perform the job. However, this is always challenged, and these have shifted and changed over time. For a long time, things like physical standards were used as a way to exclude certain individuals with disabilities or women from police forces because they couldn't meet certain thresholds. These have been changed, and in most cases, there's found a balancing where a policy or standard is now implemented that does not unnecessarily discriminate, but still provides for individuals to perform their duties effectively. And so with that, I'm going to pass it over to Rachel to talk more about undue hardship.
Thanks, Andrew. Okay, so you've been hearing Andrew talk about the general framework of the duty to accommodate and this concept of accommodating to the point of undue hardship. So let's talk a little bit more about what that means and why it's an important concept. So as you can probably expect, and as Andrew's been talking about, the obligation on an employer to accommodate its employees is not unlimited. And so there is this concept in human rights laws of the principle of undue hardship, which really strives to strike a balance between the competing interests of the person in need of accommodation and the party, here the employer, granting the accommodation. Now, important to note that the undue hardship assessment is going to be made on a case-by-case basis and is going to be guided by a measure of proportionality. But I do want to stress that this is a fairly onerous standard. And so, an employer has to be prepared to demonstrate that it has taken an active role in assessing an individual's accommodation needs, and that it's considered the options available to it and has appropriately assessed the impact of providing an accommodation, and whether that impact in the particular circumstances of that case is going to rise to the level of undue hardship. Now, on the slide here, we have, I realize I haven't flipped the slide for you. There we go. So on the slide, we have a number of factors that we typically consider, or an adjudicator is typically going to consider in assessing whether an employer, whether accommodating would amount to undue hardship. And those are factors typically like cost, health and safety. Depending on the jurisdiction, these will vary. So, for example, in Ontario, the only factors that are to be considered are health and safety, cost, and outside sources of funding. Factors like business inconvenience or employee morale or customer or third-party preferences are not valid considerations. So say the adjudicators. Now, again, as I said, this varies province to province. And so, for example, in BC, an employer could rely on cost. It could rely on morale of other employees and take into account size of the employer's organization and interchangeability of workforce and facilities. So there's a number of variations, but generally speaking, these are sort of the key factors that an adjudicator will consider. Which leads us then to ask, what are the limits of accommodation? How far is an employer supposed to go? First, employers are not required to modify bona fide occupational requirements, which Andrew has already taken you through, obviously noting that these are challenging to establish in most cases. The other thing is that employers are not required to alter the essence of the contract of employment, which is the employee's duty to perform work in exchange for pay. Now, the duty to accommodate doesn't require exempting a person from performing the essential duties of the job. So you don't have to fundamentally change the working conditions or, for example, assign the essential duties of a position to another employee or change those essential duties of a position. In cases like that, where you can't, for example, accommodate someone within their existing role, you may, however, need to consider alternative work, whether that's on a permanent or temporary basis. You may need to consider things like job bundling or reassignment to an open role or retraining for an alternate position if that wouldn't constitute undue hardship. Or you're thinking about things like providing leaves of absences while you continue to search for a role that in which you can accommodate an individual. Let's delve a little bit more into this concept of cost being undue hardship. So really, this is something that we often see employers pointing to is the cost. And while it can be a very valid consideration, we need to be mindful that we have to really be able to demonstrate the cost. So the cost of a proposed accommodation arrangement would be considered undue hardship only if it's quantifiable, if it's shown to be connected to or related to the accommodation, and if it's so high that it really affects the viability of the organization or threatens to change the essential nature. And so it really has to be a prohibitive cost. And for many employers, that's not really going to, measure up or be something that an employer can rely on, particularly large employers. So when you're thinking about the cost of accommodation measures, you're thinking about the size of your organization and the relative financial means of the organization. You're thinking about the timing of the costs and your ability to spread it over time or across the organization. And you're thinking about the availability of other resources or outside resources like government grants, tax incentives, et cetera. So we have up on the slide here a few different examples of costs that you could be considering. And again, this may be a difficult one for large organizations to meet. Let's talk more about health and safety, which is one which we can often try to fit ourselves into. Now, health and safety risks really mean or are about the health and safety of the person both requesting the accommodation as well as other employees or general members of the public or persons that will be coming into the workplace. Now, employers, of course, have an obligation to take reasonable precautions to protect the health and safety of workers. That is an obligation that is in place across health and safety legislation across the country. And so here, what we're really trying to do is balance the interests of multiple parties and your competing legal obligations, both from a human rights perspective in accommodating the person who requires that accommodation in the workplace, while also ensuring the health and safety of that person and others in the workplace. You need to consider the type of risk and the consequences of the risk, as well as the probability of that risk materializing. And we need to, as in all cases, and this isn't just because we're lawyers, although it probably is in large part because we're lawyers, we need to be basing this on objective evidence that we can bring forward and show to an adjudicator. So it has to be a health and safety risk that is not sort of based on speculation or stereotypes. It has to be really grounded in sort of objective facts and objective information. Right here. So with that, let's delve a bit more into the accommodation process, which, as Andrew noted, is such a critical aspect of the accommodation analysis and the legal burden that the employer is going to have, and just practically is a process that you need to undertake in order to assist your employees in the workplace and to limit your liability. So we've got sort of a bit of a step-by-step process here that we'll take you through. And as with everything, you always want to be considering accommodation on a case-by-case basis at an individual employee level or individual personal level, rather than sort of having just general policies or sweeping statements about what you can and cannot do. So we need to sort of at every step consider this on an individualized basis. So first, we need to consider whether we even have a duty to accommodate. So has our duty been engaged? And so at this stage, we have to consider, is there a prohibited ground? Is there something that is protected by human rights legislation that is at issue in the facts that you're looking at? And then is there an adverse impact or effect that's being experienced by that individual? And then finally, as Andrew had taken us through, is there a nexus or a connection between that prohibited ground and the adverse effect? This is really essentially at this step, you're considering, is there a prima facie case of discrimination here? Is there something that requires accommodation? And as Andrew noted, once that prima facie case is there, is present, has been established, then the burden is going to shift to you. But again, you're thinking first, is there a duty to accommodate? Has that been engaged? If so, then, and really as part of that first step, you are going to be sort of gathering and assessing, thinking about and collecting information in order to consider whether there is possible discrimination or something that requires accommodation, and then to proceed through the accommodation process in order to sort of consider what, if anything, you can do to the point of undue hardship. And so in this respect, you're going to gather the relevant information. You're going to speak to employees. You're going to understand your company policies. You're going to consult internally about, all of the various aspects at play here. And this is really important that, we're not doing this in isolation. We are talking to the employee. We are collecting more information. We are thinking about, do we need medical information in order to understand what a particular individual's needs may be. So, I know there's a question in the chat about what kind of, can we ask for medical documentation? Yes, absolutely. No. Yes, you can and you should. And in fact, when you are thinking about disability accommodation, which we'll get into a little bit more, you're really going to need to understand the particular individual's restrictions and limitations. Like, what exactly is it that requires accommodation, so that you can then consider what measures you can take in your workplace in order to accommodate or help that person. And then, our step 2B here, we want to really consider our options. So explore the options, document the options that we've thought about. Really, like, we go back to sort of our teachers and them telling us to show our work. This is really what we're doing here, and what's really important in the accommodation process is thinking about and showing the steps that we've taken to consider, to ask questions, to inquire of employees what their specific needs are, and then to really canvass and assess our options in the workplace. So show your work, document it all, and take sort of an informed decision. Again, going back to what Andrew said, offering reasonable accommodation. And not just, what someone is specifically asking for, although if you can do it and you want to, that's great. But offering reasonable accommodation, not necessarily the individual's preferred accommodation. And I realize I went too far here. So just going back to sort of implementing it. Once you've made a decision about what the accommodation is, then go ahead and implement it and follow up on it. So don't forget about it. Accommodations are not necessarily always permanent. They can be temporary, and your workplace is not static. So there may need to be adjustments made over time. And so you should always be looking back and thinking about whether an accommodation needs to be adjusted, reviewed, reconsidered, reassessed, whether you need more information, or, if you get more information from an individual, how does that need to be accounted for in your accommodation process and in the accommodations you've given. And if you're not able to accommodate, we need to get back to the individual and explain to them why we can't, and what other options there may be at that point. Okay, and so I think we've been alluding to this all along, but really, this is a joint process. Accommodation, you're not alone in that process. An employee is obligated and has a duty to participate in the accommodation process as well. So for better or for worse, you're not alone. You've got the employee, you've got other people in your organization that would be involved, of course, but employees are involved, and unions also have a role to play in the accommodation process. Now, that doesn't mean they have a general right to participate in all matters of accommodation, of course, absent there being something in the collective agreement that says so. But it is really viewed as a tripartite sort of process, one involving both the employer and the employee and the union, if there is a union. So just a couple of key reminders and takeaways that we've been going through. What you're going to need to show in each type of accommodation is really going to vary, but important that you keep really good records of what you have come to learn, the steps that you have taken, the options that you have considered, and really documenting all of your steps, communications, and conclusions. So you can always be thorough here, and it's really going to help you in showing an adjudicator that you've taken really diligent care. And we'll talk about some cases as we go along where perhaps that wasn't the case, and that became a real challenge for an employer through the adjudication process. So let's jump into disability accommodation and just as a recap again, what is a disability? It can be a physical disability, it can be a mental disability, it can be perceptions of disability or beliefs that an individual has a disability. So it's a really broad definition. It's not going to cover sort of temporary ailments like cold and flu, but something that is really an ongoing limitation. So as you're considering whether you can accommodate a disability, you are going to want some key pieces of information. So you're going to first of all want to know whether there is a disability. You're going to want proof of that. And you're going to have to think that's going to be sort of a contextual thing. What exactly do you need? Is it very obvious and you can, the individual is coming forward to you and telling you and you understand and you can see it, is it a visible disability that is is more obvious, or is it something that is not visible? There are a number of mental health disabilities or other sort of invisible disabilities where you may not know. And really, as an employer, your duty to accommodate is only triggered where you know, or you ought reasonably to know, that somebody has a need that needs to be accommodated. So we'll just go through quickly, and being mindful of the time, a case example of disability which touches on the bona fide occupational requirement. So in this case, this is a case that arose out of the COVID-19 pandemic, where in response to public health masking mandates, an employer that operated a food processing and logistics facility implemented a policy that required all employees to wear face masks at work. Now, the individual at issue had a health condition or disability that meant that they could not comply with this policy and wear a face mask. And so ultimately, the employer stopped scheduling that individual for work and placed that individual on an unpaid leave of absence. In this case, it was not really disputed that there was prima facie case of discrimination. All of the elements of that test were met. The employee suffered from a medically supported phobia, in this case, that was triggered by wearing a face mask, and that medical condition was a disability and prevented that employee from complying with the masking policy. And it was clear that there was an adverse impact on that individual's employment because they weren't permitted to work and they were placed on an unpaid leave of absence for a number of months as a result of their disability and therefore their inability to wear a mask. Now, in this case, the employer raised the bona fide occupational requirement defense. And in this case, the arbitrator upheld or dismissed the grievance, finding that there was a bona fide occupational requirement in having this masking policy. Now, as Andrew mentioned, the first sort of two steps of the test there, that it was adopted for to protect health and safety in the workplace, and that it was, enacted honestly and in good faith. There was no real issue there. The issue was whether it was reasonably necessary. And at that time, the arbitrator considered the context at that time, the COVID-19 pandemic, the masking requirements, the public health guidelines, very transmissible and lethal nature of COVID-19 at the time. And it was in that context that the arbitrator found that that it was reasonably necessary for this policy to be in effect in order to achieve the health and safety goals of the employer. And of course, the arbitrator looked at other health and safety measures that were in place. And so ultimately, the arbitrator concluded that permitting the employee to return to work without wearing a face mask and without being certain that physical distancing could be consistently maintained introduced an unacceptable level of risk that amounted to undue hardship in that case. So again, very much a contextual analysis that the adjudicator will engage in to assess whether or not there is a bona fide occupational requirement. And, we would query whether something like that today would be upheld, or really whether it's at the time that it was in place that it was found to be reasonably necessary. And I'll turn it back to Andrew to take us through some more case examples.
Thank you, Rachel. And just so everyone knows, I know that we had some of those technical difficulties, so we might go a little bit longer today. We note that there's a lot of questions that are coming up in the chat, which is great. This is a topic where lots of people have questions, so we want to be able to answer some of those questions, although we likely won't be able to get to all of them. So we'll be going a little bit longer today. Please feel free to stay as long as you can so that we can make up some of that time that we lost. And so next I'm going to talk about one that can be particularly difficult and one that's recently top of mind with COVID and COVID vaccinations, which is creed and religious accommodation. And so the different legislations have different names. A creed is something that's provided for in the Ontario and Saskatchewan human rights legislation. Alberta has religion, a religious association. It's a bit different in every province, but essentially, in each case, it's not usually defined. But But what the tribunals and the commissions have held a creed or religion to be is something that covers religious beliefs and practices, something that can also cover non-religious beliefs and systems for provinces where we have creed that substantially influence a person's identity or worldview or way of life. One of the key things that always causes conflict with employers in determining accommodation and whether accommodation is legitimate is the determination of creed and discrimination on the basis of creed and religious is bound up with an individual's personal or of subjective understandings of their religious or creed. Kind of as we talked about, an employee's misunderstanding or an employee's sincerely held belief, even if not held by all members of their creed or religion, can still be a protected ground that needs to be accommodated. But it doesn't include things, practices, or beliefs that are only marginally or not sincerely held or connected to, how the person identifies with their religion or creed. And so the legal test of when an employee has a religion or creed that's protected is that it has to be sincerely, freely, and deeply held. It has to be intricately linked to the person's identity. There has to be a particular comprehensive overarching system of belief that governs how the employee lives or operates. And it has to, in some way, address the ultimate question of human existence or about how one should live or what one's purpose is or if there's an afterlife or what's the intention of existence or higher moral authority, whether or not that's a god or something else. And there has to be some nexus or connection to the organization or community that shares that belief. And so it's easy in the context of recognized religions to say, okay, whether or not somebody has a protected ground in terms of whether or not they're Christian or they're Islamic or they follow Judaism. Each of those are clear. It gets a little bit more difficult when we're evaluating, and sometimes it has come up, creeds that are not necessarily linked to common doctrinal religions. But the thing is, and the issue that we have to get over, and what we try to discuss our clients, is that there still is a duty to accommodate if an employee does come forward and say that they require an accommodation based on a religion or a creed. And we need to be careful about making assumptions or presumptions about an individual's belief, particularly whether or not it's sincerely held and whether or not there's any value to it. Often, one of the issues that come up is that employers will rush to judgment about certain belief systems or certain ideas and not want to accommodate those things because they don't think they're reasonable or they think they're wrong or they personally disagree with them. The purpose of the Human Rights Code or including creed and religion in these Human Rights Act is to protect employees who may have different points of views from their employers so that they're free from discrimination. But again, you can request information. This is a process. You're entitled to determine whether or not somebody has a protected ground or is a protected characteristic which they are entitled to accommodation. So you can collect information on what they say, their religion. You can ask what faith or what creed they follow. You can ask for information about that. You can request usually additional information from the employee themselves, or you can seek out or have them complete information from their convocation leaders or priests or religious leaders to provide more details and context about what the belief is and how their belief is at odds with whatever standard or act they're alleging is discriminatory. And it's crucial, again, to record all efforts when determining whether or not a faith-based accommodation can be provided. And so one type of religious or creed-based discrimination that comes up fairly often has to do with certain uniform requirements or certain PPE requirements. And PPE, I mean personal protective equipment. It's come up a number of cases involving hard hats, where members of certain faiths have to wear their hair a certain way, and that interferes with the ability to wear a hard hat. And it also come up in the case of Sikh employees, where they're required, or by they're not required, but it's a tenet to have facial hair. And that can pose a problem where there's a safety reason to wear a respirator, because in general, if an individual has a beard, they're not able to get a proper seal on a respirator, and they're not being able to use that device. And so in one case, specifically a grievance with the Hamilton Paramedic Service, that was the exact issue, is whether or not an employee could be accommodated to grow their facial hair and not wear the standard issue respirators. And the union, of course, met with the employer and pointed out that the respiratory device wouldn't be able to provide an adequate seal. So the question is whether or not there was an accommodation. And the union in this case asked to be provided with a power air purifying respirator. And so essentially this is a type of respirator that can go over your head, and which essentially has a hose and almost into a vacuum that goes into an air filter. And this can, in some cases, be an alternative to a normal respirator. And by respirator, I mean a mask. But the issue in this case is that there were specific rules that required the paramedics in certain circumstances to wear helmets, and where in this case the helmets that were required to be worn by regulation to meet that safety standard wouldn't allow this employee to be accommodated by a power air purifying respirator. And the union brought a grievance and held that the employer failed to properly accommodate, but the arbitrator found in favor of the employer. The employer found that there was, in this case, a bona fide occupational requirement for having to wear a respirator. It was the purpose of the requirement was clearly health and safety. It was rationally connected to the performance of their duties, and it could not be accommodated in this case because employees had to wear specific types of respirator masks in order to work with their hard hats. If they were to allow this employee to wear the power air purifying respirator, they would not have been able to meet the other safety requirements, which was the requirement to wear a hard hat or a helmet. And so these are the types of analysis that have to be undertaken when you're looking at creed or religion. One of the ones that has come up more commonly, which I'm sure many people are aware of, is individuals who refused vaccinations in mandatory workplace vaccination policies arising from COVID-19. And in that case, again, there is a wide variety of cases that unhelpfully fall on a number of different sides as to whether or not individuals had a sincerely held belief that refusing a vaccination was a core tenet of their employment, of their religion. The most common reason for alleging that they could not receive a vaccination is the argument that vaccinations were related to fetal stem cells that were derived from fetuses decades ago, which are either used in the process of developing vaccinations or in the research which led to the vaccinations. And so these requests for accommodations have actually fallen on both sides, or the decisions arising out of them has fallen on both sides of the coin. Generally, arbitrators and commissions have held that employees are able to show that there was a sincerely held belief, specifically that abortion was wrong, that belief is attached to their religion. Christianity generally has accepted that there are restrictions against abortions in certain circumstances. That's, at least in some Christian faiths, a belief. And then the question has always been, and which has come up in the cases, whether or not that religious belief was so inherently connected to getting vaccinations, because we know that various churches all over the world have said there's no problem with getting vaccinations. We're not against vaccinations. But many employees claimed that they had a sincerely held belief that getting a vaccination that arose out of what they allege were fetal stem cells or stem lines was contrary to their belief. The cases, like I've said, have come on both sides, with some more restrictive jurisdictions, such as Alberta, finding that no, there's not a rational connection there. But there are decisions, especially at different times of the pandemic, which have found that there was a connection there. And it often depends on the evidence that's presented. And so, of course, hindsight's 2020. But in all cases, what's really important is that you document the reasons and you document the evidence that has led to decisions to accommodate or not to accommodate on the basis of religion. And so I'll hand it back to Rachel, who's going to talk about family status.
Wonderful. Thank you. Okay, so let's jump right into it. What is family status? What I'll say there is that there is no uniform definition across Canada. So what I have up here is the sort of definition for Ontario. Which is, really means the status of being in a parent and child relationship. Now, that goes both ways. So parental relationship to a younger child and sort of a child relationship to an older parent. So thinking about childcare and elder care sort of responsibilities. That's typically what's engaged in the family status analysis. So what's the legal test? You won't be surprised to see the question will be, is there a parent-child relationship? Is the individual in that relationship? Have they experienced adverse treatment at work? And is the fact that they're in a parent-child relationship a factor in that adverse treatment at work? So this is, here we are back at our sort of prima facie discrimination test. If these factors are at play and the test is established, then we ask, then we go down our accommodation route and we think about how we can accommodate that individual. So let's think about our accommodation plan, as always, and be mindful of the fact that we are seeing family status accommodation requests and cases being on the rise. I would say probably 5-6 years ago, they weren't as frequent as they are now. Even maybe 10 years ago, they weren't as frequent. And now we see them a lot more often. And so this is something to start really wrapping your mind around. And as Andrew has said, don't dismiss requests outright. Really think about, in particular, around sort of shift changes or changes to typical shift times. That's often where we see family status issues coming up. And so, be mindful and be attuned to this possibility of a family status bearing on the individual's need and request. And think about and ask questions. So clarify what the impact is on the individual, what their exact needs are, for how long. Think about if there are other alternatives or options, depending on the jurisdiction, for that individual to sort of accommodate or take measures themselves to meet their needs without their needing to be impacted in the workplace. But really go through your process, ask all the questions. Oftentimes a questionnaire can be a really great way of getting at and better understanding a family status related need. So speak with the employee, put questions to them in writing if that's helpful, or if you're having a hard time getting the answers that you need. If there's sort of a medical element to it, also get that information as well. And then proceed with your accommodation process, thinking about what, if anything, you can do to make arrangements in the workplace to facilitate that employee's participation. So I'll talk briefly about a case where, this really went sideways. We didn't the employer in this case, unfortunately, didn't go through their process and experienced lots of challenges as a result. And this is a Ontario Human Rights Tribunal case involving an employee who worked day shifts in a technical position at a commercial laundry facility. Now, that employee and their spouse cared for 3 small children and also had elderly parents who had significant health challenges. And the evidence before the tribunal was that the employee's schedule had been modified in the past. There had been accommodation put in place to account for that individual's family status needs. And with a new manager coming in, unfortunately, and after that accommodation being in place for a year, a new manager came in and decided to take sort of a unified approach towards employees' hours without any exceptions, and essentially told the employee that they needed to leave their modified schedule aside and get on the sort of unified approach schedule right away, without really giving much opportunity for discussion or really any advance notice. And so the employee in this case continued to work the modified schedule despite being told not to, and was disciplined and ultimately terminated for violating the scheduling policy. Now, the employee made efforts to talk to the employer to think about and try and find some reasonable alternatives, but the evidence really was that the employer did not. And here there was, if we think back to the legal test, there was a parent-child relationship, in fact, going both ways in this case. There was clear adverse treatment, the requirement to conform to that uniform start and end time for a shift. That was, the adverse treatment. And that parent-child relationship was a factor in that adverse treatment that ultimately led to termination of employment. And so, again, the employer in this case just unilaterally revoked the accommodation. They weren't able to show that they engaged with the employee in the accommodation process, that they considered options, they considered the employee's exact needs. And really the employer expected the employee to make significant changes to their childcare arrangements in a matter of days. So unfortunately, in this case, the employer was found to have failed to meet their procedural and substantive duty to accommodate. So lessons learned from this, and, good cases and bad, we really can learn from these cases and appreciate the importance of going through the process and documenting your process. And again, considering how a neutral rule and an insistence on a neutral, on compliance with that rule can have an adverse impact, and the need to consider variations or exceptions to that rule. In this case, it wasn't clear whether the employer would have been able to prove a bona fide occupational requirement. The evidence really didn't go that direction because there wasn't really much consideration given to that in the course of the employee's employment. And then again, difficult to prove undue hardship or difficult to prove that you've met your procedural duty if you haven't engaged with your employee. And so really going back to basics, like asking questions, making sure you understand, and taking an individualized approach to assessing an employee's needs and the ways in which you may be able to accommodate those needs in the workplace. And with that, I think we have a few minutes left for questions. I'll turn to Andrew. I think Andrew's going to take us through some of those.
Sure. I think maybe I'll ask you a question first related to some accommodation, and then I'll handle a couple. So regarding ongoing disability, what is an employer's obligation to accommodate temporary restrictions? For example, things like graduated return to work. Although that might make sense for the employee, is it required by an employer?
Great question. And I think when we talked about disabilities, we talked about the fact, and accommodations generally, we talked about the fact that accommodation may be permanent or may be temporary. And particularly with disabilities, you have sort of this ongoing obligation to accommodate. And really here, I think your analysis is not going to be any different in respect of, well, it will be slightly different in respect of a temporary restriction compared to a permanent one, but We would have generally an obligation to accommodate gradual return to work. So those are very common. Modified, whether that's graduated return, a couple of days a week, or a reduced schedule, reduced number of hours per day. That could certainly be something that you may need to accommodate. Again, you're going to need to go back, ask the employee and maybe the employee's physician what exactly the restrictions and limitations are. And then you're going to consider whether you can accommodate those restrictions temporarily through graduated return to work or some other temporary means. And there you're again going to think about, would accommodating that amount to undue hardship? Particularly with temporary restrictions, that may be more challenging to prove. So again, go through your process and ask the questions to understand the circumstance.
So I'll take one. So one question related to me bringing up COVID was one of our viewers has said that there was an individual who provided documentation from the Archdiocese, so assuming they're Christian, indicating that they could not receive the COVID vaccine based on religious grounds because it had a particular ingredient, which was one of the same ingredients in Tylenol. And so the viewer wants to know, would it have been able to ask if they do take Tylenol, and if indicated yes, could you refuse accommodation? So this question's interesting, and it goes to a sense of, proving the validity of a request for accommodation. And this has come up in a number of cases because there were examples where certain ingredients that individuals were objecting to were found more broadly. And so what I'll say is that, questions of that nature are certainly relevant and reasonable because it goes to an individual's sincerely held belief. If an individual is living their life in a certain way that's not necessarily being consistent with these values, then it could potentially be argued that they don't have a sincerely held belief, and perhaps they're refusing the vaccination for other reasons. But I'll say that by itself, you have to be careful of jumping the gun. I mean, sometimes individuals might not be aware of all the ingredients in certain medications. And so it's not simply enough to say, it's not a complete gotcha moment in that case to say that that's sufficient. So again, it's one thing that you could consider, but it's not, you still have to do a well-rounded consideration of whether or not that there is a sincerely held belief there. So I think our slides have moved on. And so wanted to, again, thank everyone for joining today. For those of you in Ontario and Quebec, the CPD certificate QR code is on your screen and the link is within the chat. And if you don't get a chance to use the link, certificates will be sent out next week. For BC viewers, the Law Society BC title has been added to the chat as well. And again, we apologize for the technical difficulties. I'm sorry we weren't able to get to all of your questions, but thank you very much for joining us today. And while this is the end of our EDI series, we do have a fall series on of our LEHR webinars beginning November 5th, with our next presentation being Pay Transparency, Canadian Laws and Global Trends. Thank you very much for coming. If you'd like to register for any of our other events or watch any replays of previous events, you could visit the Fasken Institute section of fasken.com. Thank you very much and have a great afternoon.